You're live.
Good morning, Michael. This is Chris Marr and Michael DiRienzo. This is our Friday morning legal topic that we have an ongoing discussion on. We tend to pick a different topic or series of topics each Friday, and we have found that these discussions that we have tend to be helpful to many clients of ours and people who aren't our clients who just watch and listen in. This morning, our topic is the landlord tenant moratorium on evictions. We're really confining our discussion to New York landlords and New York tenants. That's the state of New York. And it's the latest out of Albany, out of the governor's office, is that this eviction moratorium that has been in place for the past year is about to expire on January 15, and it does not appear, Michael, that the governor's office is going to extend this moratorium, which is a relief to our clients who are landlords, and they tend to be small landlords, most negatively affected by this moratorium. It's a system that was created by executive order of the governor's office, the moratorium, and the fact is that it has ground evictions in the courts to a halt. I don't know what your experience is, Michael, with our clients, but the bottom line is that if a tenant wishes to avail themselves of the protections of this executive moratorium, that they need to file certain paperwork. The paperwork under this system would have been forwarded to them, or at least notice of their availability forwarded to the tenant by the landlord. And this applies generally to commercial and residential landlords and tenants. The tenant then has to take certain steps and produce certain forms of proof. It's not just a system where the tenant can say, I'm having an extreme hardship and I can't pay. And the tenant has to produce other forms of proof with that. So have you had any experience, Michael, with tenants and landlords under this moratorium?
Yeah. So first thing that should be really, I guess, noted is that the governor had her State of the Union address yesterday, and a lot of people were expecting her to actually say something in relation to the moratorium. But the fact of the matter is, she pretty much stayed quiet on it, which goes to show that more likely than not, on January 15, 2022, when the moratorium is actually set to expire, what's going to happen is that things are going to move to somewhat back to normal situation pre-COVID. And so the important thing for tenants to remember is that just because the moratorium is over does not necessarily mean that you lose any and all rights that you had. New York is still a very tenant-friendly area. And so what that means is you have very certain rights that have to occur. So a landlord can't just come in and evict you. This is a situation that a lot of people don't understand, is that even though the landlord the landlord, it's his property or his or her property. What happens is that there are still legal rights that the tenant has, even if they no longer have what's called a month-to-month situation, or excuse me, a lease, and you're on a month-to-month situation, which is kind of the default what happens when you don't have a lease. So there are still very certain rights that the tenant has. And so if you are a tenant and you're experiencing hardships, one of the options that was available to you was through the moratorium. What was called is the COVID-19 hardship declaration, which you're correct, you had to fill out certain paperwork to not only the state, or excuse me, not only the landlord, but also the court. And the purpose of that was not is usually related to when you actually get what's called an eviction notice. Not necessarily you can just kind of do it on the offensive. It's a defensive to basically tell both the court and the landlord to say, I'm trying, but COVID has caused all these hardships, and you're 100% correct. What you have to do is you have to fill out a lot of different things to say. You can't just say COVID bad, therefore I get certain rights and you can't touch me. Here's what I can prove under. You have to actually swear to it under oath to say that this is exactly what happened. I lost my job, my business went under. I had to take care of this. Somebody passed away. Things like that, which you have to really had to prove. And so for tenants, that at least as of where it stands today at 8:45 on the January 7th, is we're sitting here today where that no longer is going to be more likely an option. That being said, we've been in front of courts all throughout this entire time. And what we've explained and what we've noticed is that a lot of courts or a lot of judges are still very hesitant to kind of make any decisions without a lot of due process, probably more due process than you're going to see in a lot of other states, more because of that landlord, the tenant's rights and the rights under the state of New York that tenants have. So if you're a tenant, what this really means to you is that you're no longer going to have the automatic stay, but you're still going to have a lot of different various options, which we're going to get into in other topics. Now, what happens if you're a landlord? Now, landlords, what the next step is going to be is that we would recommend at this point that we're all kind of waiting and seeing to see what's going to happen, because as we were saying before, judges are very hesitant, and they're all just kind of, for lack of better terms, punting to see after the moratorium to see kind of to get things back to normal, because the moratorium created a lot of confusing rights, which a lot of judges really weren't quite sure what to do. And so in due process terms, they're kind of waiting to see what would happen afterwards. So the landlords, so if a landlord called us, and we've actually had a few this week, what's going to happen is we're going to kind of start the process back up exactly as if nothing happened, that COVID wasn't an issue. And so there are still a lot of certain steps you have to take, and even if they haven't paid for you in 3 years, if they've been there for 3 years, then they're still have the tenant still has a lot of rights to before you can actually kind of get an eviction notice and get them moved out. But when you work with an attorney like us, if we work with an attorney like us, we can kind of work with you to figure out different ways that within the law that what could have happened. And we just got a question from arguably the best realtor in Putnam County and maybe the state of New York, is what happens if your tenant has paid and it's just a nightmare. So this is another crazy thing. So your tenant, right? What happens is if you're a tenant and you have to pay $5,000 a month in this crazy large house that you're renting in the state of New York, and you saw this a lot out in the Hamptons. And so they paid you $3 that month, and you accepted it because $3 is better than zero. Now, what's crazy is under the law in the state of New York, and this is going back to what we're talking about, the fact that the New York is a very tenant-friendly state, is that the state of New York is actually going to basically consider that the fact that you accepted those $3, they're more likely than not going to consider that as a restart of the process. So it actually gives the tenant an additional 30 days under all the various things and the protections under the law. So, if it's a situation that what we were just saying, it's a crazy nightmare and things like that, and they've only paid $3, but they haven't paid it in a long time, before you actually accept and take in those $3, we always recommend that you talk to an attorney first, because even that acceptance of that kind of not a lot of money will actually create a new process under the state of New York that will actually give you more headaches, as crazy as that sounds.
And what we have learned is that this eviction moratorium does not, at least on paper, does not protect troublesome tenants who are, as that questioner just raised with us, uh, nightmare tenants. Uh, there's situations where the nightmare is not related to any COVID condition, or arguably is not related to any disability in terms of being able to work, things like that. It's just a typical nightmare tenant for a landlord. And our recommendations have been and continue to be that the landlord aggressively prosecute those eviction proceedings as if there was no moratorium, as you indicated, Michael, and that the landlord bring to the attention of whatever the court is that this eviction has nothing to do with an inability to pay rent due to COVID or anything of that sort that would have caused a protection under this pandemic relief moratorium that was created by then Governor Cuomo, and is due to expire next week. So our position is that if there's no true COVID related disability here that would prevent the tenant from relocating and vacating our client's property, that our position is that the moratorium does not exist for the purposes of that tenant. And it's worth noting for clients who are tenants that the fact that there is or has been a moratorium that's about to expire does not relieve the tenant of the contractual obligation, whether it's a contract by handshake agreement or a contract by a written lease, from paying that rent that would otherwise have been due and owing to the landlord. So the bottom line is that, and we appreciate that question from that broker who happens to be my beloved wife, that the bottom line is that landlords should be on notice that they should handle these situations, cognizant, of course, of the fact that there may be a COVID related basis for extending this moratorium, at least in this specific case. And if a tenant applies for certain types of relief, financial relief from the state, and there are those avenues that it can extend the client's tenancy, that our landlord clients should proceed full ahead with whatever their statutory remedies are for vacating that troublesome client and proceeding to protect their properties. So thank you, Michael.
Thank you. Stay happy New Year, stay warm, stay healthy, and we'll see you next week.
Yes.